While Buster Murdaugh agrees that his dad has psychopathic characteristics, he still thinks the jury got it wrong and his dad's innocent.
Buster admits that he's confused by some of the evidence presented at the trial earlier this year, but ultimately he still thinks his father is innocent of murder. So right now, Alec is serving 2 life sentences for murdering his wife Maggie and his son Paul in 2021 to allegedly cover up financial crimes. Buster says he thinks that's a weak motive. Buster explains the moment that he learned his mother and brother were killed. It was in a phone call with his father. And he insists now, over 2 years later, he still has no doubts his dad is innocent of murder.
Did you ever go there and say, maybe it's possible that he did this?
No, because I think that I hold a very unique perspective that nobody else in that courtroom ever held.
Alex Murdaugh. We got some new updates. Now, if you didn't know, this is the guy that's been charged with killing his son and wife. His son that's alive still has his back and believes he is innocent. He's literally ride or die. And Alex Murdaugh's attorneys, defense attorneys, Jim Griffin and Dick Harpootlian, filed a motion for a new trial based on allegations that the court clerk, Becky Hill, pressured jurors to return a verdict of guilty in order to sign a new book deal. Not only that, and that trial was interesting. If you haven't seen that trial, we covered it here together. That was a roller coaster. There was legal professionals that had stated their opinion before the trial verdict was in. And they said that the way everything was looking, a lot of people thought it was either going to be a hung jury or not guilty. And it turned out to be guilty because they thought it was just such a circumstantial trial. So we have these accusations of jury tampering from the court clerk. Not only that, which was very interesting, by the way. We covered it. I'll put the links down below because they actually had some sworn testimony from jurors. But they also want to throw Judge Newman off the case because they say that he was a witness to the matters that took place. So it would be like a conflict of interest. And then also they cite that he was on NBC's Today Show and he was on a panel at this university, Cleveland State, and that he made some comments. I quote, "In my mind, no doubt he loved his family. I don't believe that he hated his wife and certainly do not believe he did not love his son, but he committed an unforgivable, unimaginable crime, and there's no way that he'll be able to sleep peacefully." And so they're saying that this is like some type of thing where they're arguing that the judge's comments flout the code of judicial conduct. They're saying Mr. Murdaugh's right to have an appeal heard by an impartial judge will be violated if Judge Newman proceeds to hear his motion for a new trial. So let's get into the state's response to the motion for a new trial. The court clerk is firing back. South Carolina versus Sled. Alec. Richard Alec was convicted for the murders of his wife Maggie and Paul by a jury before the court in Carleton County, March 2nd, 2023. This court sentenced Murdaugh to consecutive life sentences of life without parole on March 3rd, 2023. After filing a notice of appeal and during the pendency of that appeal, Murdaugh filed in the Court of Appeals of South Carolina on September 5th, 2023, a motion to suspend appeal and for leave to file a motion for a new trial. On October 17, 2023, the Court of Appeals granted the request to hold the appeal in abeyance and remanded the matter to this court to permit Murdaugh to file his motion pursuant to Rule 29B. Murdaugh so filed with the Carleton County Clerk of Court on October 27, 2023. Murdaugh broadly claims that he is entitled to a new trial based upon allegations that the Clerk of Court of Carleton County, Becky Hill, improperly attempted to influence the jury's decision. In support of his claim, Murdaugh offers affidavits from one juror who participated in deliberations, one who was removed for dishonestly concealing her own improper communications about the case, and 2 hearsay affidavits from his counsel's paralegal. Murdaugh additionally advances a sweeping conspiratorial theory about wholly irrelevant Facebook posts with scant evidence to support it. The state responds as follows. So the thing with those Facebook posts, and I'm going off the top of my head, from what I remember, they got rid of this juror and they had found some posts that, I don't know if they said it was her husband or her ex. She wasn't with the guy, but they said that she was in communication with this guy because this guy posted something about the trial. And this person had actually, she was like, this person, I think she had a restraining order. This person had DV stuff and she was afraid of this guy. and they see some sort of post, which I don't think they ever proved. They never showed his post, but they said he mentioned something about the trial. And it's believed, the claims from the Murdaugh people is that they wanted to get rid of her, the prosecution, because she was skeptical and had questions about him being guilty. She didn't think he was guilty. And so the allegation was that this court clerk made up something about Facebook posts and that she was talking about the case when she's not supposed to. Now, the thing is, she actually hadn't talked to this guy in years. And all of a sudden he's calling her because of what happened. Murdaugh's people also reached out to this guy, and I think they had like sworn affidavit or something, and he said he never posted that. And they said it turned out to be somebody that's not even him. It's just somebody with the same name. So they're saying that they threw her out for no reason. Now, okay, law and procedure. Colorable claims of after discovered improper external influence on a jury may necessitate a judicially conducted inquiry to confirm the validity of the verdict as free from external influence, through which defendant must show actual prejudice. The law permits but skeptically receives motions for new trials based on after discovered evidence, and never does the law permit highly motivated convicts to put their own jury on trial. There can be no doubt that motions of this sort should be received with the utmost caution, because as it is said by a learned judge, they are but few cases tried in which something new may not be hunted up, and also because it tends to perjury. It would be a mischievous tendency, after all the evidence on the part of the state had been fully disclosed, to allow one with his life in danger an opportunity, by the assistance of Confederates, to procure unprincipled witnesses to contradict the evidence on the part of the state, and thereby defeat the ends of justice. So they're saying that they have a sworn affidavit from the juror that was thrown out, and one of the jurors that I guess maybe replaced that one, that was there for the deliberations. Do you think that they should have a hearing for this, about this? It's pretty interesting, even if it's just one juror, though. That page, those documents that they sent had a lot of information, the Murdaugh people. And also, if they do, should Judge Newman be allowed to preside over it, or should they have a different judge? It says, nonetheless, criminal defendants have a right to a fair and impartial jury, and private communications or contact with jurors during a criminal trial about the matter pending before them may necessitate an evidentiary hearing, and if the defendant can show actual prejudice, a new trial. This court has long held the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. Not every inappropriate comment by a member of court staff to a juror rises to the level of constitutional error. Were that the rule, few trials would be constitutionally acceptable. Additionally, jurors are presumed to follow the law as instructed to them, to include instructions of what constitutes proper evidence to consider in deliberations. And such instructions are usually deemed to have cured the erroneous exposure to improper evidence or argument. Where a defendant knows or could have known of a constitutional issue at the time of trial, the defendant is obliged to timely raise that issue to the court's attention, or else waive it on future appeals. Where a defendant does not learn of a constitutional violation until after trial, the defendant is obliged to seek relief within 1 year of actual discovery of the violation, or when it could have been discovered through reasonable diligence, or within 1 year of the sending of the remediature from appeal. A prima facie showing that a defendant is entitled to relief is necessary before an evidentiary hearing can be granted. A jury poll may cure any procedural irregularities and can confirm that each juror approves of the verdict returned, and that no one has been coerced or induced to agree to a verdict to which he or she does not actually assent. If that prima facie showing is made, the resultant evidentiary hearing is a strictly limited, judicially conducted affair, particularly as concerns examination of the jurors. Competency of jurors as witnesses is strictly circumscribed by the rules of evidence. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations, or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental process in connection therewith, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any jury. Nor may a jury's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. Generally, juror testimony is not allowed regarding the deliberations of the jury or internal influences. Both the Supreme Court and Court of Appeals commended the trial court's deft handling in Green for the process it followed in investigating its own allegations of improper communication between a bailiff and a member of the jury. The trial court questioned each juror in the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. So they're referencing another case, Green. More specifically, the Honorable Donald B. Hawker, immediately after publishing the verdict, cleared the courtroom of all present save the lawyers involved in the case. The clerk and the judge staff then brought out each juror individually and polled them on the record, asking the following questions with minor variations. Was your verdict guilty on both charges? And is the verdict still your verdict? Was your verdict based 100% on the testimony, evidence, and the law presented at this trial? Was your verdict influenced in any manner by any communications with any of the bailiffs or any other person outside of the 12-member jury? Did you have any communication with any of the bailiffs or with a third party not part of the jury? And if so, please relay to the court what those communications were. So this was State versus Green appeal case. Upon learning that a juror had introduced a religious pamphlet concerning God's view on capital punishment to the rest of the jury, the trial individually questioned, and that's pretty interesting, somebody did that. The trial court individually questioned the jurors to determine who, if anyone, had read the pamphlet and what the information was contained in the pamphlet. The trial court also conducted the questioning in State versus Bryant using questions submitted to the parties after they learned of improper contact with jurors by an investigator. Thus, the established practice is that when considering allegations of inappropriate communications, the court should voir dire the complaining juror, each juror who engaged in the final deliberations, and the alleged improper communicator. In this case would be the clerk, with a mind to at least, one, whether the communication actually occurred, and if so, its context and substance. 2, the number of jurors exposed to the improper communications. 3, the weight of the evidence properly before the jury. And 4, the likelihood that curative measures were effective in reducing the prejudice. But for proposed questions submitted and subject to judicial pre-approval, the court should not permit interrogation of the jurors by the parties or their attorneys. Jurors are citizens who have committed a tremendous service to their community and country through the sacrifice of time and effort to weigh on the most serious issues that can be put to them: a man's guilt and his freedom. Jury duty is a cornerstone of civic duty, and needless exposure of jurors to legislative stress and impeachment by zealous attorneys, particularly in a case of with this level public exposure, can only serve to further discourage citizens from willingly participating in this duty. Trial. Near the end of Murdaugh's trial, separately sourced reports of improper discussions and social media posts were brought to the court and investigated, resulting in the excusal of juror 785, who now raises allegations he or she expressly denied to the court when examined. Portions of the trial transcript illuminate or are otherwise relevant to resolving the allegations now raised by Murdaugh. The state excerpts and summarizes them as follows. A, the court consistently instructed jurors not to discuss the case and to only consider the competent evidence presented in the courtroom. Once the jury was selected, the court promptly admonished the original 18 jurors that it is important for you to know that are not to discuss the case with each other or anyone else, and not endeavor to find out any information about the case other than what you will see here in the jury, the courtroom. A break, and during the court's preliminary instructions, it again emphasized the importance of not discussing the case and accepting only the evidence presented in the courtroom. Until I tell you that it's time to do so, you cannot discuss the case with anyone, including your fellow jurors. You cannot discuss the case with family, friends, or anyone else. The attorneys in the case, you cannot discuss it with them or any parties or anyone else that might be connected with the case. Should you discover that a fellow juror is violating that oath and that order, you are to bring it to my attention. Now, it is also, and it's vital that you do not seek information outside of the courtroom during the case. That means that you're not to search internet websites, watch television reports, news reports, or any other form of social media accounts of the case, because you are sworn to decide this case based on the facts as you determine them to be, and based on the evidence presented in the case, as well as the law as I give it to you. So, I mean, so far it's, I guess, somewhat interesting. They're reiterating everything that's said during a trial, which is kind of like holding the jurors accountable. Like if this happened, you were supposed to report it. But also, still, we've still got a ways to go. But like the court or clerk, if it's true, you shouldn't still be talking about the case or telling people things. Or there was a lot of different allegations on that Murdaugh stuff, like they weren't allowed for cigarette breaks, which I actually probably maybe makes sense if you're a juror deliberating. Different things, but it's also interesting. Like these are some really, really serious allegations, right? And here they're fighting to not bring in the jury, to not bring him back, because that's too much or whatever, what they say. They did their duty and that's it. I say bring him in. It says here constantly throughout the trial and even at points during jury selection, the court reminded and admonished jurors not to discuss the case. So a bunch of referencing all these times. Okay. And it's charged to the jury at the end of the case. The court instructed the jury they were to accept only evidence presented, that they were the sole judges of credibility. You are to consider only the testimony which has been presented from this witness stand, along with other exhibits that and evidence presented during the trial. Any other evidence or exhibits which have been made a part of the record you may consider, along with any stipulations made by counsel. You are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who have testified in the evidence offered. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. In addition to the dozens of times the court told the jury, do not discuss this case, prior to the close of evidence, the court again instructed jurors, if your deliberations necessitate an overnight break, you may use these electronic devices as necessary, but you may not use them to communicate with anyone about the case until this case is over. The court further instructed jurors that an overnight break in deliberations was a possibility, and that if they so broke that they were not to seek information and should avoid the use of electronic devices. Certain statements attributed to Clerk Hill by juror 630 closely resemble statements made in the court by the state. The parties made their opening statements on Wednesday, January 25th, 2023. The state, as part of its own opening statements, advised the jury. You're going to see video statements of Alex Murdaugh. You're going to see a body-worn camera of him at the scene when law enforcement arrives and hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progressed about what he says. And what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right, or does something seem a little off? Does something seem a little off about this? Emphasis added. The jurors so complied and were closely attentive throughout the trial. At the end of its initial closing argument, the state implored the jury to not let Murdaugh fool them. This is what he did. This is what he did right here. This defendant, on the other hand, has fooled everyone who thought they were close to him, everyone who thought they knew he was who he was. He's fooled them all. He fooled Maggie and Paul too, and they paid for it with their lives. Don't let him fool you too. Emphasis added. Later, the state, in its final closing argument, returned to the subject of body language while addressing the testimony of Michelle Shelley Smith. Do you think she knew right then? And that's real. That's real. Shelley is real. You saw her. Body language is so important in life. Body language. Mr. Waters was talking about the defendant. All of our body language. Did you see Shelley's? Emphasis added. The jurors were not fooled. Pay attention to body language and convicted Murdaugh. The court thoroughly investigated allegations of improper communications by juror 785 and ultimately dismissed the juror for those communications, but gave no weight to the supposed Facebook post reported to the court by Clerk Hill in a conversation which was placed on record. On Tuesday, February 28, 2023, after the conclusion of the reply examination of Kenny Kinsey, the court initiated a camera hearing regarding an email that raised juror concerns. In sum and substance, the email represented that the unidentified author heard from an unidentified co-worker that said co-worker's landlord was a juror who said Murdaugh was innocent, and that said juror works at the monkey farm. Murdaugh's counsel advised the court to disregard the email as mere noise in a high-profile case, but the state expressed concern about the allegation of clear violation of the court's instructions to the jury and noted there were still alternate jurors. Counsel Griffin speculated without support that the email was an orchestrated effort to get the juror removed. The court informed the parties of its exchange with Clerk Hill, who had evidently learned of the email. The court, okay, after I showed you all this email, we came back here and the clerk came in and asked whether we had heard the same thing about the juror, and we were in the midst of trying to figure out who the juror was that this pertained to, since it did not indicate a juror number. It just said someone who worked at the monkey farm. So the clerk then said that she was reading her Facebook messages over the weekend. Gabby, help me out with the fact. Did she say over the weekend? Law clerk, she said on Friday she was going through her timeline on Facebook and saw the post from this man who was supposed to be the ex-husband. The court, yeah, ex-husband. The ex-husband of the juror, and his post was that she was discussing the case with various people. I think that's what Becky said. The law clerk, correct. The court, we asked Becky to the clerk to make a copy or get a copy of the Facebook that she was referring, the post that was referring to. She came back a little while later and said that it had been deleted by this ex-husband and that she printed out what remains on his post, which was him stating that he posted an ugly post, which he deleted. Substance of a Facebook post apology, humorous exchange between Mr. Medders and Mr. Harpootlian. The court, but the clerk said that she read the post where he was discussing that his ex-wife, the juror, has been discussing the case. Now, it was very curious. We were talking about the email and the clerk came in and was talking about a Facebook post, and and she said the juror works at the monkey farm. I was here trying to figure out what juror works at monkey farm, and this juror number 785 works at business name Yemees, South Carolina, which is monkey farm. The court and the clerk said the juror that they were posting about was a juror 785, who works at the monkey farm, and this email referenced the juror who works at the monkey farm. Counsel Griffin suggested bring juror 785. The court agreed and noted its desire to also hear from Clerk Hill, who was not present at the time, but had mentioned the Facebook post earlier that day. After some discussions by the parties as to the appropriate procedure and the desire of the complainant to remain anonymous, as well as other trial procedural matters, the court conducted an in-camera examination of Juror 785 to discuss any conversations that Juror 785 have had with anybody about being on jury duty. As part of a brief discussion about a missive allegedly posted to Facebook by Juror 785's ex-spouse, Juror 785 noted that Clerk Hill had alerted her to an alleged post. The court specifically followed up and asked, the court says, so has Clerk Hill, discussed the case with any of you, any of the jurors? Has Clerk discussed anything about the case with anyone on that jury? Juror says, not that I'm aware of. Ooh. So this is so they come back, they're hitting back. Counsel Griffin, then satisfied, accepted Juror 785's explanation and argued he and she remained a competent juror. Upon the state's expressed desire to know the identities of the persons who reported the improper contact to the court again summoned Juror 785 and elicited additional information sufficient to identify the persons with whom the juror allegedly had an improper conversation. Two of the Juror 785's tenants, hereafter referred to as male tenant and female tenant, shortly after 9 p.m. that evening, agents with the South Carolina SLED located them, interviewed them separately, and prepared a memorandum and recordings reflecting the interviews. On March 1, 2023, the 27th day of the trial, the tenants met with ADAG. David Fernandez and DAG Donald J. Zelinka, and executed affidavits consistent with their statements to law enforcement the night before, which stated that juror 785 had delivered a refrigerator to them on Saturday, February 18, 2023, and briefly discussed the case. After the jury view and the state's initial closing, the court convened another in-camera hearing to review the affidavits and examine juror 785's tenants. The court asked the male tenant about his affidavit, and the male tenant explained that he offered his opinion about the case to the juror 785, who had disclosed their role as a juror while speaking to the female tenant while they were delivering the refrigerator. Juror 785 had replied to the male tenant that she hadn't. Juror 785 replied to the male tenant that she hadn't decided either way, okay, because it was, it was kind of early in the case. I guess, that she made no decisions if he was guilty or if he wasn't guilty. The state then reviewed with the male tenant his affidavit line by line, which he confirmed was accurate. When Counsel Harpootlian asked the male tenant to elaborate on line 9 of the affidavit, in which male tenant recalled that juror 785 stated that she didn't believe there is any evidence to make her think that the defendant was guilty at the time. Male tenant expressed that he took her to mean she had not made up her mind yet. So she stated she didn't believe there was any evidence to make her think the defendant was guilty at the time. The court next examined the female tenant. The female tenant explained that juror 785 disclosed while delivering the refrigerator that they were on jury, which prompted the male tenant to offer his opinion as to Murdaugh's guilt. Female tenant recalled juror 785 replied, "Well, I can't talk about it," she said, "but as of now, nothing. Reasonable doubt could make me say he's guilty." When pressed by counsel Harpootlian as a direct reinstatement as female tenant could muster, female tenant recalled juror 785 said that she could not, without, a doubt or whatever, say he was guilty. So she's saying she has doubts, I guess. Juror 785 did not explain to female tenant why she held that position. Female tenant reaffirmed her recollection in her affidavit that juror 785 indicated that she didn't believe there was evidence beyond a shadow of a doubt or beyond a reasonable doubt that Mr. Murdaugh committed the crimes he is alleged to have committed. After hearing arguments from attorneys for each of the parties, the court noted that in many cases, typically without any inquiry, this juror would be gone, which I have to agree. After seeing and reading this stuff, I have to agree. Without anything further, the juror would be gone without any discussion because she's discussing the case and was ordered not to discuss the case. Even if she discussed it for a very short period of time, she's having a discussion so much that this person understands that it shouldn't have taken place and sent the email. The court then summoned Clerk Hill to discuss the supposed Facebook post. And outside of the Facebook post thing with the supposed ex-husband, it's enough with these people, the tenants, to get her thrown off. Clerk Hill explained to the court that she briefly saw a post preceding Friday on Walterboro Word of Mouth, which she attributed to a juror's ex-spouse, which said that H3 noticed that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be and that he was the ex-husband. But she was known for talking way too much. And then I just kept scrolling because that was enough for me. I've gotten enough. Clerk Hill figured the post referred to juror 785 and alerted the court after learning the court had received an email the following Monday. When Clerk Hill tried to find the post again at the court's directive, she could not, but found another post by another account with the ex-spouse's name that apologized for deleting a post made while drunk and possessed by Satan. After some discussion about the feasibility of finding the devil-afflicted suspected ex-husband, the court asked if the parties would wish to locate him. Counsel Harpootlian very clearly declined. "I think not, Judge. I think if you would just accommodate me, bring juror 785 in, ask him about the specifics of the conversation. If juror 785 says yes, I'll have no complaints whatsoever." The court complied with Counsel Harpootlian's request, again summoned juror 787, informed them the court had met with the tenants and asked if the juror could recall anything further about the conversations. Juror 785 acknowledged delivering the refrigerator and that the tenants had expressed opinions about the trial to her about the trial, but denied expressing any of the jurors' thoughts to the tenants. Denied expressing any thoughts of the jurors to the tenants. So she denied what she said too. After discussing juror 785 ruse to claim they were in Facebook jail during trial, which I don't know. What do they mean? The ruse. Is that what they claim to try to get out of this? I don't know. During trial and irrelevant particulars of their employment, counsel Harpootlian astutely observed the juror 785 placed their spouse at the scene of the conversation. Juror 785 called their spouse, put them on speaker, and upon brief examination by the court, juror 785's spouse said the juror was talking with my tenant's girlfriend, I think. And you know, I know they talked about the trial, but I don't know to what extent, if you know what I mean. Well, I never seen this before. The spouse further explained nobody was saying like, you know, guilty or innocent, but that they were talking about some of the facts that had come out in the case either way, you know. The spouse also acknowledged talking if there was any excitement in juror 785's day each evening, but that they did not talk details. Finally, the court granted counsel Harpootlian the opportunity to confront juror 787 directly with their tenants' affidavits, which the juror denied as inaccurate. So hold on, I'm confused. So the tenants are saying she was talking about the case. She's saying she wasn't. And I think the ex-husband is saying she did. Once 785 was excused, and after a very brief explanation of the witnesses, counsel Harpootlian declared, I'm not going to argue anymore about this. I'm going to defer. It's your call, your judgment. Your Honor, I'm not going to argue with whatever you do. Okay. The following morning, March 2nd, 2023, after reviewing the video recordings of the interviews of the tenants, the court excused juror 787 from service for offering her opinion regarding evidence received up to the point of and during the conversations with the tenants. Counsel Harpootlian affirmatively declined to take any exception to the ruling. Juror 785 was summoned to the courtroom, advised of the court's ruling, and upon inquiry about a conversation this morning with Miss Becky, the court emphasized this ruling had nothing to do with anything brought up about the juror's ex-spouse. Jurors 785's possessions to include a dozen eggs, which you guys remember the whole egg thing.
To preserve the integrity of the process and in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs?
Yeah, one of the other jurors brought in eggs for everybody for the farm.
Okay.
Eggs, my purse, and water.
All right, well, you're going to leave the eggs? You want to leave the eggs or take the eggs? You're going to take the eggs.
Were retrieved from the jury room, and juror 254 was promoted from alternate to panel. The jury, which never deliberated with juror 785 or the alternate 741, convicted Murdaugh of killing his wife and son. Upon inquiry by the court, counsel Harpootlian requested that the jury be individually polled. The court so polled each individual juror, affirmed guilty was their verdict and remained their verdict. So, yeah, they did poll each one. Less than 1 week later, attorney Joe McCulloch represented to media that juror 785 did not wish to speak publicly about the case and did not wish to be contacted. Rachel Sharp, infamous egg juror in Alex Murdaugh's murder trial, asked to be left alone. I guess this is like the title of an article. The Independent, March 8, 2023. At some point unknown to the state, McCulloch also assumed representation of the jurors 630 and so represents each of the jurors who have provided affidavits to Murdaugh. State's motion to strike. In support of his motion, Murdaugh provides various affidavits which are deficient under the South Carolina Rules of Evidence, notwithstanding any effort by the state to grapple with the affidavits in its arguments in sections 4 and 5 below. The state must respectfully move to strike portions of Murdaugh's motion for a new trial as follows. A. The state moves to strike as inadmissible hearsay the affidavits of paralegal Holly Miller. In support of his motion, Murdaugh provides two affidavits from counsel Harpootlian's paralegal Holly Miller, which largely purports to reflect statements made to or otherwise in her presence by two jurors 741 and 326. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Hearsay is not admissible. An affidavit from Miller is not tantamount to an affidavit from the juror themselves, and constitutes textbook hearsay. Accordingly, the state moves to strike in part as inadmissible hearsay motion for a new trial Exhibit B at lines 4 through 11, Exhibit J at lines 2 through 9, and any such part of the motion that relies thereon. But I thought those jurors signed those affidavits. B, the state moves to strike as inadmissible under Rule 606B all such material as regards internal functions and deliberations of the jury. In support of his motion, Murdaugh provides 4 affidavits which purport to reflect statements made by jurors, which in part pertain only to juror mental processes and interactions with one another. As previously noted, jurors may neither testify nor may the court accept affidavits which pertain to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or another juror's mind or emotions, accepting claims of outside influence or extraneous outside information. Rule 606B, denying without a hearing a defendant's motion for a new trial and refusing requested inquiries as prohibited by Rule 606 because they would cause jurors to reveal the subject matter of their deliberations. Remarks in the affidavits regarding the jurors' thoughts about the evidence or one another are not properly admissible or even relevant to the ultimate claim raised. Accordingly, the state moves to strike in part as improper juror testimony, motion for a new trial exhibit, and then these are the exhibits. C, the state moves to strike all such material as regards Murdaugh's claims regarding the Facebook post, book deal, and post-trial media interactions as immaterial, impertinent, and scandalous. The greater part of Murdaugh's motion is dedicated to an outlandish theory that Clerk Hill deliberately fabricated the existence of a Facebook post implicating juror 785 in order to get them removed from the jury, force an outcome, and thereby profit from fame and fortune. To be clear, in an attached affidavit, Clerk Hill affirms she made no such deliberate fabrication. She denies fabricating any Facebook post, Exhibit A. Indeed, the machinations alleged do not even begin to make sense. Under Murdaugh's theory, Clerk Hill heard the court had received an email which implicated a specific juror, then in immediate response on the fly reported a fictitious Facebook post to implicate the same juror, then conspired with another staffer to quickly and by sheer coincidence be lucky enough to find an apologetic post by somebody with the same name as the juror's spouse, which she then reported to the court in an effort to get an uncertain juror removed so as to ensure some outcome that would support a book deal she did not at the time have. Only Alex Murdaugh could conceive of such a confounded gambit as even remotely plausible, and he is projecting his own calculating, manipulative psyche onto a dedicated public servant in an effort to save himself. Strategically, Murdaugh's inclusion of the Facebook post narrative appears to be a desperate effort by Murdaugh to preemptively impeach Clerk Hill, to bring into dispute irrelevant facts in order to support his petition for a writ of prohibition pending in the Supreme Court of South Carolina, and to beef up what would otherwise be a thin, blandly legal filing, not likely to draw attention to the various media efforts of his legal team. Whatever Murdaugh's motivation, the court expressly did not rely on the alleged Facebook post in removing juror 785. Therefore, whatever Clerk Hill saw, the alleged post is mistaken as to the alleged post, or even fabricated. It is of no consequence to the validity of Murdaugh's conviction or the actual claim raised by Murdaugh of improper external influence upon the jury. Accordingly, the state moves to strike entirely the motion for a new trial, and moves to strike in part motion for a new trial with all these other exhibits. Number 4, argument. Number 1, even assessing ad arguendo that all the facts averred in Murdaugh's motion are true, the motion fails to make a prima facie showing that he is entitled to an evidentiary hearing or relief. Although Murdaugh's motion for a new trial makes various allegations as part of its attempt to craft a breathtaking conspiracy narrative, it ultimately boils down to a single constitutional allegation. Clerk Hill told jurors do not believe defendant, thereby violating his right to an impartial jury. Accordingly, even if the state assumes at arguendo that all of the competent elements of the affidavits provided are earnestly given, the relevant analysis is as demonstrated by the questioning of State versus Green. 1, was the juror's verdict guilty? 2, was the juror's verdict based on the evidence presented? 3, was the juror's verdict influenced the alleged outside communication? Number 4, did the juror have any communications about the case outside of deliberations with the jury? All of the other details are irrelevant window dressing. Only one juror who participated in deliberations, juror 630, ties to Clerk Hill. Any statements remotely consistent with Murdaugh's allegations of improper external influence, not to be fooled, watch him closely, look at his actions, look at his movements. Even assuming for the sake of argument that juror 630's recollection is accurate and that he or she is not misremembering arguments expressly made by the state, juror 630 does not attribute their verdict to the statement of Clerk Hill, but rather avers that he or she voted guilty despite some questions because juror 630 felt pressured by other jurors, quote unquote. That a juror felt pressured by other jurors is not a valid basis to impeach a verdict, nor does juror 630's complaint of feeling pressured by other jurors constitute evidence that he or she or any other juror voted to convict because they felt influenced by the comments they allegedly heard from Clerk Hill. Murdaugh offers an affidavit which purports to represent statements made by juror 326. Although the affidavit is that of Counsel Harpootlian's paralegal Holly Miller, even if the state accepts at our arguendo that Miller's affidavit is equivalent to an affidavit from juror 326 themselves, it is unavailing to Murdaugh. Juror 326 contradicts juror 630 and recalled no such comments by Clerk Hill regarding Murdaugh's credibility. What juror 326 did recall was a warning that the jurors would witness disturbing images, which is a neutral trigger warning and not one which puts a thumb on the scales of justice. To be sure, the jurors did review disturbing images. No affidavit attached to Murdaugh's motion from or about a deliberating juror shows any effect on the verdict, even including juror 630. Nothing else offered by Murdaugh helps meet his burden of making a prima facie showing. Neither juror 785 nor juror 741 participated in deliberations and thus cannot aver that their deliberations were influenced. Absent any representation that a deliberative juror's decision that Murdaugh was guilty was actually influenced by the improper communications alleged, Murdaugh has failed to make the prima facie showing necessary to justify so much as an evidentiary hearing, let alone a new trial. Accordingly, Murdaugh's motion for a new trial should be summarily denied. Argument 2, should the court deem an evidentiary hearing necessary, the state expects the material allegations will be shown to be not credible. In the alternative, in the event the court concludes Murdaugh has made a showing sufficient to necessitate an evidentiary hearing in this matter, the state expects that sworn testimony to the court will prove the allegations to be unfounded and not credible, since Murdaugh's filing of the South Carolina Court of Appeals agents with South Carolina have successfully interviewed most of the jurors and the final alternate juror. One juror declined to discuss the case or deliberations, juror 578, and 2 jurors are represented by attorney Joe McCullough, jurors 630 and 785, who at the time of this writing has yet to consent to an unconditional interview with his clients. Clerk Hill denies commenting to the jury regarding Murdaugh's defense or testimony. Exhibit A, affidavit of Mary Rebecca Hill, and it says upon information and belief SLED's investigation into the allegations of jury tampering produced the following answers from the jurors who deliberated. So let's just start with the first box here, and it's asking, did you hear remarks on evidence by Clerk Hill? So juror 193 says no, maybe generally pay attention. Juror 254 says watch Murdaugh's body language. Juror 326 says no, graphic material warning was given. Juror 530 says no. Juror 544 says no, generally pay attention, look at the body language and be observant. Juror 572 says no. 578 declined to discuss the case. 589 says no. 630, no interview at the time. 729 says no, generally pay attention, heard no body language comments. 826 says no. 864 says no. Did you see one-on-one chat with Clerk Hill and the jurors? So 193, no. 254, no. 326 says yes. Financial/child support. 530 says no. 544, no. 572, no. 578 didn't want to discuss, declined to discuss the case or deliberations. 589, no. 630, no interview at the time. 729 says the same thing. Financial/child support. Chat with others. 826, no. 864, no. Now, the next question on here, if you had any other concerns, I'm only going to say the ones that had concerns. 193 says, if anything, people were overly cautious. Juror 544 said, Juror 630 is a tenant of Juror 785 who is upset. Warned by counsel Harpootlian of a subpoena if they did not talk. 589 says, spouse warned by Harpootlian of a subpoena if they did not talk. Interesting. 729 says, denied statements regarding them in the affidavit of Juror 785, uncomfortable when Harpootlian waved the gun around. So there's a part in the trial where this guy, it's like locked in, position safety, but he waved it around. 864 says, it was Creighton Waters in court argument who told the jury to watch body language, which I think that's part of what they're trying to say as a possibility that maybe they just remember that during the closing arguments. In addition to the jurors, SLED interviewed court staff jury coordinator Willard Polk Jr., reported that he was the interface between the jurors and the court and did not hear Clerk Hill or any other person attempt to influence the jurors. No other court staff witnessed any external influence on the jury side either. Exhibit C, redacted written statements of certain court staff. Altogether, the allegations raised in the affidavits provided by Murdaugh can be explained as a combination of simple mistakes and, unfortunately, a non-credible affiant. As noted previously, a brief review of the records reflects that the verbiage Juror 630 recalled is, as Juror 864 noted, more properly attributed to arguments of the state. See Section 2B. The state argued to the jury to not be fooled by Murdaugh. The state advised the jury to watch Murdaugh closely in the context of his video recorded statements, and the state emphasized the importance of body language. Juror 785, purportedly the landlord of Juror 630, was removed from the jury after the court determined that he or she improperly conversed about the case with other tenants during the trial in contravention of the court's dozens of admonitions not to do so. Juror 785 only recalled the fooled by language, which was actually articulated by the state in its closing arguments the day before Juror 785 was dismissed. But most importantly, the court specifically asked Juror 785 during the in-camera hearing if Clerk Hill had discussed the case with her or any other jurors to her knowledge, and Juror 785 replied, not that I'm aware of. It strains credulity to believe that Juror 785 would not be aware of Clerk Hill's supposed statements when specifically asked by the court at a time proximate to when they were allegedly made, but would suddenly recall them many months later after learning Clerk Hill published the book. The remainder of Juror 785's affidavit reports incredible one-on-one conversations with Clerk Hill, which, aside from Juror 785's inconsistent but more than credible denial to the court, pertain only to the wholly irrelevant Facebook posts. Finally, contrary to Juror 785's affidavit in support of the motion for a new trial, the tenants of Juror 785 affirmed the statements they made in their affidavits at trial and in camera testimony. Alternate Juror 741 would not sign an affidavit as requested by Murdaugh's counsels and was evidently reluctant to do so. Juror 741 told SLED investigators that Clerk Hill told the jurors that the defense is about to do their side and don't let them confuse you or convince you. They may say things to confuse you. However, neither Juror 630 nor Juror 785 clearly corroborate Juror 741's recollection, and no other juror even comes close to doing so. Juror 741 told SLED that she was aware that Clerk Hill wrote critically of her attentiveness during trial, and additionally noted that Clerk Hill told her after the trial that no members of the media wished to speak with her. The greater weight of anticipated juror and court staff testimony is that Clerk Hill made no materially improper comments. The state denies Murdaugh is entitled to relief and anticipates that any evidentiary hearing will only reaffirm the validity of his conviction for the murders of Maggie and Paul Murdaugh. Furthermore, even if Clerk Hill made any improper comments to the jury, the state has found no juror who will aver that anything Clerk Hill said or did influence their verdict. The court clearly instructed jurors to consider only the competent evidence presented to them and apply the law as the court gave it to them. The jury presumptively and affirmatively did so. Each individual juror reaffirmed their verdict when polled by the court, and none reported any influence from any other court staff. The court's instructions to consider only the competent evidence and individual polling procedure after the verdict was returned served to dissuade jurors of any misconceptions which may have developed over the weeks-long trial and cure any errors which may have otherwise resulted. Conclusion. Wherefore, the state respectfully requests that this court summarily deny Murdaugh's motion for a new trial, or, barring that, convene an evidentiary hearing consistent with that conducted in State v. Green, and upon hearing the testimony of the jurors and witnesses presented, find Murdaugh's allegations to be not credible and deny his motion for a new trial.
And Brooke, the South Carolina Court of Appeals issued a ruling today. It allows a lower court to determine if those allegations are credible.
Yeah, Greg, so this ruling does not grant Murdaugh a new trial, but I'm told it does open up the door for that to become a possibility.
This ruling was not a surprise.
It doesn't surprise me at all.
Tuesday, the South Carolina Court of Appeals issued a ruling allowing Alex Murdaugh's attorneys to put the appeal of his double murder conviction on hold. This allows a lower court to hear their concerns of jury tampering.
This is a significant and serious issue that has to be resolved, and the Court of Appeals is not the place for these type of issues to be resolved.
Murdaugh's attorneys feel the Colleton County Clerk of Court may have influenced the jury's opinion of Murdaugh. That clerk, Becky Hill, denies any wrongdoing.
It's a big if whether there was tampering.
The case would be heard by Judge Clifton Newman. That's the same person who oversaw the double murder trial. But attorney Eric Bland says he expects Murdaugh's lawyers to file a motion to disqualify Newman from hearing this issue.
And it's up to Judge Newman to make a decision on whether he can be fair and impartial.
Comment down below. Let me know what you think. Does Murdaugh have a chance? I feel like when I first saw what they filed, I was like, oh, wow, maybe they do have a chance. And now I'm kind of like, very small, not really, probably not chance. By the way, there's supposedly a financial trial scheduled for November 27th. Will it actually happen? I don't know. Curious if you guys want to watch that. That's the part that dragged out the most that we were watching during the murder trial, but it probably would be interesting to see him again. They're trying to change the venue because they don't feel they're going to find an impartial jury, which I don't know. And here's something else that's interesting. Court documents state that out of 167 questionnaires returned by the jury panel, 147 panel members admitted to having prior knowledge of Murdaugh's crimes. Murdaugh's attorneys argue they would have a difficulty finding jurors in upstate. Murdaugh pleaded guilty to similar federal financial charges September 21st. Anyway, thank you guys for watching. Take care. Like, subscribe. Peace.